Welcome to our session on the nation-state and international institutions focused on Israel and the International Criminal Court. With us in the studio are the Honorable Irwin Cotler, a globally recognized human rights advocate, and his daughter, Member of Knesset Michal Cotler Wunsh. I will introduce them both more at length after giving a little more context for our discussion. The International Criminal Court, a tribunal established to prosecute war crimes and crimes against humanity, recently decided to open a probe into the state of Israel in a suit filed by the Palestinian Authority several years ago. The probe is set to explore, among other things, allegations of war crimes in Gaza in 2014, as well as the charges that Jews are settling in occupied territory, namely in their ancestral homeland of Judea, Samaria, and Jerusalem, which is considered a crime, potentially, under the language of the statute that authorized the court's creation. The court should not have jurisdiction in this case, even by its own rules, but seems to be proceeding. Pro-Israel advocates and conservatives see this as a mere pretext for the continued weaponization of international institutions against the Jewish state, following a long pattern of actions and statements made by UNRWA, UNESCO, and the Human Rights Council, to name only a few UN bodies. It's increasingly common for both US and Israeli conservatives to see these institutions as fundamentally political, dominated by anti-democratic forces and human rights abusers, who then claim equal or stronger footing to sovereign, free, and democratic states. Continued participation in these forums often feels like we're giving legitimacy to a rigged game. But with us in the studio are two staunch, incredibly accomplished advocates for Israel who want to advance a different or complementary perspective. And so we're going to try to understand a bit more what's happening in this case and then have a larger discussion about Israel and international institutions. Again, I'm going to introduce our guests and then we'll proceed. So it is a real privilege to be hosting Irwin Cotler. He is the chair of the Raoul Wallenberg Center for Human Rights, an emeritus professor of law at McGill University, former Minister of Justice and Attorney General of Canada, longtime member of Parliament, and an international human rights lawyer. He served as counsel to prisoners of conscience all over the world, including Andrei Sakharov and Nathan Sharansky, Nelson Mandela, and imprisoned Saudi blogger Raif Badawi, among many others. He is highly decorated for his leadership on human rights and has received 14 honorary doctorates, where he has been recognized as a scholar and advocate of international stature. Michal Wunsh is a member of Knesset for the Blue and White Party, recently appointed as the Special Parliamentary Coordinator for the Knesset on the ICC matter. Her background is that of a legal expert and social activist. She received her law degree from the Hebrew University and an LLM from McGill University in Canada. Currently, she is writing her doctoral thesis in law at Hebrew University. She has extensive experience in the world of law in the Israeli public and private sectors and also worked in mediation, formal and informal education, and engaged in extensive public activity during the years in which she lived in Canada. Thank you both very much for being here. So, Irwin, you were a leading advocate for the creation of the ICC and a deep believer in its mission. What do you think is leading it or other institutions to apply double standards to Israel, and maybe explain a bit more about what they are, please?
Well, there are double standards, and let me give you a case study very quickly that comes from Venezuela and contrast that with what's happening now with regard to the ICC jurisdiction re-Israel. Some 4 years ago, I was part of an OAS panel, what we call independent legal experts, to look into whether crimes against humanity were being committed in Venezuela. We determined 3 years ago that 7 major crimes against humanity were being committed in Venezuela. A few months after that, 7 states, including Canada, France, Germany, made the first ever collective referral of a state party to the International Criminal Court of Venezuela on the grounds that these crimes against humanity were being committed. The special prosecutor did not open an investigation. This was followed by other independent investigations which confirmed our report. And fast forward to December 2020, when the special advisor on the responsibility to protect to the Organization of American States, Jared Genzer, not only, in fact, amplified it, but it's his word, not mine, condemned the special prosecutor for not opening an investigation. Now, contrast this with the situation with regard to Israel, where the special prosecutor opens an investigation, even though Israel is not a state party to the ICC, nor has it consented to its jurisdiction. Equally, and even more compellingly, Palestine is not yet a state. even those who wish that it should be a state. It's not yet a state. Therefore, it has no authority, no legal standing to confer jurisdiction on the ICC for any investigation whatsoever. And to add to this, the investigation which determines the territorial jurisdiction as including East Jerusalem, the West Bank and Gaza, is making a predetermination of a matter which is in dispute, and where the Oslo Accords said matters relating criminal jurisdiction are totally within the jurisdiction of Israel. So what you have here is the ICC, in conclusion, breaching its own mandate, its own authority, and thereby prejudicing the pursuit of justice.
Well, what do you think is causing it to do it?
I think in this instance, some of it has to do with very poorly prepared appreciation of both the law and the evidence. I also think that the first cases that were taken up by the ICC were all African suspects, or suspects from African countries. And the cry went up by African countries, even though many of them had made the referral to the court, that the African countries were being unfairly targeted. I think Israel became low-hanging fruit, and thereby, for the prosecutor, this might look as a way of balancing going after a democracy after all the initial prosecutions have been of African suspects.
I just wanted to point out, you asked, and in your opening statement, you said it's actually about, pro-Israel advocates having an issue with the ICC. And I actually think that we really have to change the paradigm and think about it as pro-ICC advocates that need to sound their voices. So if we make this, and I believe that it's our responsibility, if we make this accessible to all trustees of international law and human rights, meaning all pro-ICC by definition, whether it's state parties or donor parties, if we make them aware of the fact that the ICC has actually transgressed or ignored or violated, as my father just said, both its foundational principles, of jurisdiction, and of course, its very mandate in that respect, then I believe that we have a much better chance of not or engaging with those that actually can reform the court. And maybe we'll touch upon about that. So I would just frame the question differently and say, what do pro-ICC advocates have to do vis-a-vis this recent decision?
I want to understand, just for people that are less familiar with the ICC, where this probe could go. What's the worst case scenario for Israel?
So first of all, I'll say that actually I've been really honored to be named the first liaison to the issue, to the ICC within Knesset. And I think that it's fundamental to understand that that means that up till now, there has been insufficient engagement, both internally within Knesset, and I'll tell you that we held a conference for all the MKs. We're all invited in order to understand the issue, exactly what you're asking right now. And we were anticipating what might happen before we knew what the prosecutor's decision would be. And also vis-a-vis our relationship with parliamentarians around the globe. So we have many formal and informal opportunities to engage. And I believe that this issue is a fundamental one on which we have to engage. And we have a responsibility to engage, as I said, as countries that are both member states of the Rome Statute of the ICC or donor countries to the ICC that are not only responsible for the way that it ensures that it fulfills its original mandate, i.e. to serve as a court of last resort for the gravest, most heinous of crimes, genocide, crimes against humanity, war crimes, but actually also have to hold it to account. So they are responsible and must hold the court to account. And it's not a binary, either Israel responds or doesn't respond. There are many other options along that spectrum of how we can handle the next steps and what they might be, what they might look like in terms of our engagement with other countries. Again, state parties to the ICC, donor countries to the ICC, the 7 countries that submitted amici briefs, and Canada that submitted their briefs that the court does not have jurisdiction, despite its decision that it does, before it decided that it does. The many international law experts that submitted amicus briefs as well. Mm-hmm. And so the court has ignored all of that, basically undermining its own principles. This is the business of every country around the world, whether they're state parties or not. If the court, in fact, has now the mandate to undermine international law principles such as jurisdiction, such as complementarity, which maybe we'll discuss a little bit further on, then every country has to lean in and or be held to account by an ICC that is not fulfilling its original mandate and rather taking jurisdiction or ignoring complementarity where it does not have that capability.
Well, I'll come back a bit later, I suppose, to what the concrete sanctions are that they might apply to Israel, because I just want people to understand what's at stake. But on the issue of pro-ICC parties, obviously Israel did sign the statute that helped establish did sign onto the Rome Statute, as did the United States, but neither of them accepted jurisdiction. And one could get the sense that it was because they were apprehensive from the get-go that there was really a political game afoot. So the Americans didn't want their soldiers prosecuted for military actions across the globe, and Israel specifically responded to the insertion of this clause on occupied territories, which was inserted, I think, at the request of Arab signatories. So we're talking about pro-ICC parties and states as if they're kind of like all of one culture or one particular perspective on this, but it sounds like even Israel and the United States, going back over 20 years, thought that there would be a problem. Right? So what does that say about the nature of the institution?
Well, you have to understand also, as Michal was saying, there are lots of other state parties, including amongst the community of democracies, and they were intervenants here, and they supported, if you will, the case that Israel was advancing, not because Israel was advancing it, but in the interests of the pursuit of justice for the ICC as a whole. Now, with regard to what might come next, I was intrigued by the fact that the special prosecutor herself said in December 2020 that she would be consulting with the new prosecutor with regard to a priorities reinvestigation. She preempted that and opened her own investigation. Now the new special prosecutor will be coming in. The question is what he might do. I just want to say, even if they go ahead with the investigation, there are still three conditions of admissibility with regard to the case. Number one, does the case meet what's called the gravity of the offense? And these are not issues here that rise to the kinds of things that Michal was talking about, real mass atrocities in international law. So, and a recent report by an oversight committee said you have to prioritize your cases in terms of the gravity of the offense. That's one condition of admissibility. The second condition of admissibility, and that's why there are three conditions, and if they're not all met, there will be no case to go forward. The second is complementarity. Complementarity essentially means that this is a court of last resort. If there are national judicial institutions that can make the investigation, then it should not substitute its views for the national judicial institutions. Israel has a Supreme Court judicial system that's respected all over the world. So just on the issue of complementarity alone, they should not proceed. And the third condition is interests of justice. All the interests of justice point in the direction of putting an end to this investigation. And frankly, I don't believe that this case will go anywhere for all the reasons that we've been saying here. And I believe that as we go further, this case will be shown not to have any evidentiary or legal leg to stand on. If we ever were to get there, you can have a situation whereby countries will simply say we're not going to, in fact, implement an arrest warrant with regard to what we think is not a case where the ICC has jurisdiction. But as I say, I don't think we're going to get there. I don't want to go through the whole process and bore and burden your audience, but we will not get past the next three stages of admissibility, even if we ever get to that point.
I just want to say on that. So I guess this is where we have sort of different perspectives. And I say as an Israeli parliamentarian, nonetheless, we may not get there, but we have to prepare for it. And that is something that I believe actually we can utilize this case and cause, even if happily we do not reach that stage of admissibility and there are no arrest warrants issued anywhere, and neither about against any Israeli civilians, because we all serve in the army, or anybody living actually in Judea, Samaria, East Jerusalem. So civilians in their civilian life, even if we do not reach that stage, I do believe that this case serves as very important awakening moment for the Israeli Knesset to understand. And again, I'm speaking, from that perspective alone, to understand the international war waged on the state of Israel, the war for public opinion waged, and we can discuss, when that was, but, we would probably agree on Durban of 2001, that implements a very, very clear strategy utilizing international institutions and the law. And this being but one case of it actually represents an opportunity, I think, for us internally to begin to have this debate and to prepare. Even if not for this specific case, it's just one single example or manifestation of that strategy, the implementation of that strategy. And maybe as opposed to some other people, I think we have to engage with that, identify it and begin to connect the dots. And actually, in order to be able to rise from the docket of the accused, not only affirm international law, which the State of Israel does, but utilize the language of rights, the lingua franca used by both our friends and our foes, by the way. So Israel's foes, when they submitted these alleged, accusations of war crimes, utilized specifically the language of rights, the language that is used by all countries, including democracies around the world, that are actually those mandated both as state parties, as I said, as donors to International Criminal Court, and the very countries that have actually just received in 2020 384 recommendations for the court's reform. This is not about Israel, and we should not let it remain about Israel, but it's also not just about this specific decision. There is an opportunity here to engage with countries around the world in order for them to hold to account and also begin to expose, after we identify the double standards, begin to expose them so that we can demand that they be addressed. Because so long as we enable them, we fail. We become complicit in the culture of impunity that enables Venezuela to continue, with mass atrocity, human rights violations. Iran, that is onlooking, though not a state party, but onlooking and empowered by the culture of impunity that is enabled by the fact that we ignore these decisions or the double standards inherent to them.
I think
just as an element point, because Michal mentioned Durban. I was at Durban. I was part of the Canadian delegation. I'll never forget that experience. What began in Durban and has continued since has been not so much as people talk about the delegitimization of Israel. That's too simplistic. What began at Durban was the laundering of delegitimization under international institutions, under universal public values. And so you have every year at the UN General Assembly, some 18 to 20 resolutions singling out one member state of the international community, happens to be Israel, whereas there are some 5 resolutions against the rest of the world combined, meaning that the major human rights violators enjoy exculpatory immunity. Right after Durban, the contracting parties to the Geneva Convention put one state in the docket for the first time for violations of international humanitarian. What was that state? Israel. To date, 3 times the contracting parties to the Geneva Convention have met to put one state in the docket. It's not been Syria, it's not been no other state. Israel's been put in the docket the 3 times. Third, under the laundering under the culture of human rights. The United Nations Council on Human Rights is supposed to be the repository of that culture. Here too, more resolutions passed against Israel than against the rest of the world combined. And finally, in terms of the struggle against racism, Durban, which was supposed to be a world conference against racism, turned into a conference of racism against Israel and the Jews. And that's the legacy with regard to the notion of Israel as an apartheid state. So we have to challenge that laundering of delegitimization, not because it's prejudicial to Israel, because it's prejudicial to all these international institutions that all these countries that Michal mentioned should be concerned about.
I mean, one could argue that the delegitimization, if we're going to use that term, started long before. I mean, the UN passed a resolution that Zionism is equal to racism.
Right, 1975, 100%.
Right? And so again, it kind of feeds into this idea that there's an inbuilt majority against perhaps Israel and against the Western powers. And when we talk about, I'm going to build a case for a minute, and then I'm sure that you'll obliterate it. But there's a couple of elements here, right? So one is the feeling that this is all inherently political, ultimately, because they're applying double standards. And then again, of course, we're talking about a majority of states that don't actually share our interpretation of legal norms and human rights that we would apply domestically, but they're talking in terms, right, that we have effectively set without necessarily internalizing them themselves. And then we subject ourselves to the result of whatever that discourse yields.
The question is just what we do about it.
Well, okay.
Right? We can agree on all of that, and then the question remains, what do we do? Do we engage?
Well, Israel's been a part of the UN the entire time, right? It didn't leave after.
Look, I remember what Kofi Annan once said to me. I never forgot it. And they said that a United Nations that does not put the combating of anti-Semitism at the forefront of its agenda is a United Nations that betrays its past and forfeits its future. So we have to make the case all the time. It has to do about the integrity of the UN and other international institutions. And that's the issue by which, as Michal said, we have to engage with the international community.
Okay. So because we're on limited time, unfortunately, I'm going to move on to my last couple of questions. Let's take your premise, which is engagement. How do these institutions rebuild trust? And I'm just going to give the conservative perspective on which I'm sure you're familiar with. I'm going to state it, and then again you can respond. So conservatives in general have become somewhat leery of institutions, even within some of their own countries. In Israel and the U.S., there's a sense that the media, the academia, government bureaucracies, public education are all speaking in a language and promoting values that are somewhat hostile to a conservative or traditional, or just a way of life. And again, that's within their own countries. And then the disconnect between who we are as a country and these other countries becomes even grander when you go to an international stage. And you are, of course, in conversation with countries, even other countries that are actual human rights abusers and anti-democratic and so on. And then the message of what happens in those institutions is then picked up again and sort of repeated uncritically by the domestic institutions. And so it again feels like when you engage in these places, that you're effectively feeding into the game and giving it legitimacy without too many tools to fight back or to engage, let's say, in the right way. So what can these institutions do to help dispel some of that feeling and distrust?
I mean, I'll take a crack at it from my end, because it's not about the institutions as far as I'm concerned. When I engage in interparliamentary discourse, whether it's, as I said, in the friendship circles that we have or all kinds of interparliamentary forums, when I engage, it's actually the countries that I'm engaging with, and specifically the parliaments that I'm engaging with, to ask their governments to be held to account, right? A donor state to the ICC has responsibility for what the ICC does. And if we know, and you said something that's very interesting, if we know today, right, that the prosecutor, even in her own decision, spoke about the limited resources of the court, and she's diverting those limited resources to a situation where she does not have jurisdiction, where there is no existing state, where complementarity would be a reason enough to shut down the entire thing, as opposed to the Venezuelan case where she does have all of those, and the limited resources have actually, at least part of her decision to not open up investigation there, presumably. By definition, those donor countries have to hold the ICC to account, but they first need to be held to account. And who are they going to be held to account by if we don't even make accessible the identified double standards that we're referring to? And what my dad described is actually precisely the double standards that in many ways, as we'll call it the canary in the mine shaft, or the predictive example of how double standards work. We also have a certain responsibility, considering the commitment to never again is not just never again to us. Never again in a world of again and again, whether we look at Syria or Iran or China, we look around the world of again and again, and we have a certain responsibility, and we can ask what that is. As a Jewish and democratic state, I feel that my Jewish values, not my international law values, my Jewish values are what require me more than any other values, I'll say that, to call out, to shout out the double standards that I identify. And it's true that I identify them because I am the predictive example. In this case, Israel being the predictive example of where the ICC or where international law is utilized in order to undermine its very foundational principles. But we don't have the privilege of not engaging with that. In many ways, in Hebrew you say, adraba, all the more we have the responsibility to engage with it, to inform ourselves, and to engage with it in a language that can be made accessible to our peers, to our colleagues around the world, each one in their own, whether it's in academia or in parliament or in government, intergovernmental interactions, in diplomacy. We have the responsibility to inform ourselves. We cannot, I don't believe, have the luxury to disengage and say, whatever will be, will be. I can't but quote Hillel in this, wise Hillel in this context and say, Imena nili mili, if I'm not for myself, who will be? But if I'm only for myself, what am I? And if not now, when? And this ICC decision for me at this historic time, and we haven't even mentioned the Abraham Accords, but we are living in a historic time, and I don't want to go off on a whole tangent. We are living at a historic time that actually enables us, but also gives us an additional responsibility to begin to expose the double standards as they affect so many others, and also to empower the voices of moderation, speaking of the Abraham Accords, to enable, for example, Islam to be taken back and taken away from the radicalization of Islam, for example. And very possibly through this decision, and with the very fact that it intersects with the reform that I spoke about. An external panel of international law scholars, this has nothing to do with Israel, 384 recommended reforms for the court about transparency, about good governance, about things that actually
about prioritization.
About prioritization that this very prosecutor ignored in her decision. I don't see how we allow ourselves to disengage when I feel that tremendous sense of responsibility to engage, certainly as an Israeli parliamentarian, certainly when I have the possibility at my fingertips to engage with parliamentarians around the world.
We have a few more minutes left.
No, I just want to say on this issue of engagement, because I think, frankly, there's Woody Allen used to quote this, but les absents sont toujours tard. The absent are always late. Yeah. And sometimes Israel's not at the table. I'm going to give just 2 case studies. I've been involved in the Parliamentary Assembly for the International Criminal Court for 18 years. Regrettably, Israel's not been involved. And until Michal was appointed, you had no parliamentary engagement by Israel re the ICC, number one. Number two, just as another example, we launched last year a World Press Freedom Conference, and that set up a Media Freedom Coalition. There are 44 members of the Media Freedom Coalition. Israel's not a member of the Media Freedom Coalition. In other words, it's not participating, and I can give many other examples, in the arenas where the community of democracies are gathering with respect to the decisions that are having an impact on Israel. And that's why I think we have to engage more. That's true NGOs, it's true the State of Israel, it's true the community of democracy, all, and it's true with regard to Israel within that framework.
I wish we had more time to explore this because, of course, the Palestinians basically went to the General Assembly and got recognized as a non-member observer, ki'ilu, as we say in Hebrew, a state, but not really. And not being a state and not having the levels of engagement that we have had with these international institutions, they seem to have an ideological compatibility with actors in these places that then works to their benefit despite engagement or lack thereof in the traditional way. However, I want to finish up actually with a different point, which is what action should be taken to hold these institutions accountable in a more concrete way?
Well, part of it has to do with doing exactly that, holding them to account. And that's what we have not been doing enough. That includes sort of naming and shaming. It's absurd that we should have a situation, and I can give many examples, that you have under the UN Human Rights Council an agenda item 7 that opens up every single UN Human Rights Council meeting by targeting Israel alone. In other words, violations of Israel in the occupied Palestinian territories is agenda item 7, and the rest is violations in the rest of the world. You have a clear, blatant violation of the UN Charter of Equality for All Nations, large and small. I'm giving that one. I can give many case studies. We have to hold them to account, do the naming and shaming, and do that in terms of what the community of democracies themselves say they are committed to. It would be the same regarding the Geneva Convention, regarding the UN General Assembly, etc., etc. We have to be engaged, we have to hold them accountable, and we have to do this as communities of democracies.
I'll just add to that, and maybe again, I speak from the perspective of an Israeli parliamentarian. The countries that are the family of democracies has to step up. And in that sense, Israel's engagement is but the first step. But we cannot be the only ones left in the sort of in the arena. And in many, many cases, the 7 countries, as I said, that submitted amicus briefs, Canada, that petitioned with a letter, international law scholars, that was but a first step. And I would call at this point all those countries. First of all, because their amicus briefs were ignored completely by the prosecutor. Secondly, as I said, all state parties and donor states to the ICC, and in fact, all countries that regard themselves, including those that are not state parties, as trustees of international law and human rights, because by the very fact, again, that we enable this decision to continue, that they enable, not just the state of Israel, that those countries that have the ability, that have the leverage, that have the responsibility to hold the court to account, and identify and expose the double standards, which undermine its very foundational principles, causing it to crumble into itself and not be able to fulfill its mandate as a court of last resort. Those are the conversations that we need to be having with countries around the world, but they need to step up, of course, and leverage what it is that they can do, including as donor countries, for example. Donor countries have terrific leverage. They don't have to continue funding an institution that does not reform itself in order to meet the reform that it itself received, and it must be held to account.
On that note, we have to conclude. I want to thank you both very, very much for coming. It was an incredible honor just to have you both in the studio. And
special pleasure to be with my daughter.
And thank you for the opportunity. This we've never done before.
Yeah.
Thank you all. I wish us all much success.